Do I need to disclose that? It's the million dollar question, like literally. And maybe the most difficult version of that to answer is I fixed this a long time ago, and I haven't had a problem since, but do I need to disclose it? Well, the answer may not be as straightforward as others have led you to believe. And let me illustrate some of the pitfalls of answering that question the wrong way by telling you about a recent case decided by the 3rd District Appellate Court here in Illinois, Poundstone versus Cook. First, I'm going to tell you the facts of the case. Next, I'm going to get into the decision the judge made and why they made it. And then finally, let's talk about some strategies you can employ as a home seller to keep you out of court after you sell the home. Back in 2016, Mr. Poundstone bought this beautiful home from Mr. Cook for $425,000. As part of the sale, Mr. Cook had to give certain disclosures to Mr. Poundstone. These are required by Illinois law, and the disclosures look something like this. There are 24, give or take, questions that a seller has to answer yes, no, or NA to. Now, in pertinent part, Mr. Cook indicated that he had lived in the property within the past 12 months. He also indicated that there were no problems with water in the basement, no problems with the foundation, or the walls, or the windows, basically answering no to all of the rest of the questions, which is pretty commonplace and also not always the best idea. Now, a couple weeks after closing, Mr. Poundstone had probably the worst experience you can have as a new homeowner, and that is a flooded basement. And when they took apart the finished portion of the basement, they discovered a ton of evidence that water had been getting into the basement for a long time. Rotted wood, mold, discoloration on the foundation walls. It was pretty obvious that this had been a problem for some time. And again, Mr. Cook answered no. He was unaware of any issues pertaining to any of those things just prior to closing. Mr. Poundstone was understandably upset, and he went ahead and filed a lawsuit. Now, one interesting thing about this case is that Mr. Poundstone did not bother to get an inspection during the transaction. It's an unusual move and probably not the one I would suggest, but it's going to end up panning out for him, believe it or not. As the case went on, the evidence did not stack up in Mr. Cook's favor. Number one, Mr. Cook admitted during trial that, in fact, he had not lived in the property within the last 12 months, which really undermined the veracity of the rest of that disclosure. Mr. Poundstone also brought forth evidence that the contractor who did the remediation work noticed that previous work had been done to remediate previous water. It was clear to him that Mr. Cook had done some work to replace water damaged wood, drywall, other things in the home, but had not gone to the source of the problem. He did not ever bother to fix the water coming in. He just bothered to fix the stuff that was getting damaged. And that was Mr. Cook's downfall in the case, because the court determined that failing to do the proper investigation into the source of the water damage was not something that Mr. Cook could rely on in making what ended up being a misstatement in the disclosure by virtue of an omission. And to be honest, as I read this case and see how things went down, it looks pretty clear to me that there wasn't a whole lot that Mr. Cook put in evidence on trial to rebut the statements made by the witnesses brought forth by Mr. Poundstone. And if the other side's got lots of evidence and you don't have that much, as a result, the trial court entered a judgment against Mr. Cook for $104,000, the cost to repair the damage. In addition, they awarded Mr. Poundstone about $35,000 in attorney's fees. So these cases can get quite expensive. Now, how are we going to stay out of court? How do we avoid getting sued for an omission of something that you might thought was fixed? We need a strategy, and that strategy is going to be all about disclosing things and owning the narrative. In most cases, I'm going to recommend that you err on the side of disclosing. And in this case, the original sin was saying nothing, letting Mr. Poundstone just sort of discover what he was going to discover. Had Mr. Cook said, hey, we had some water issues in the past, I haven't had them recently, I think Mr. Poundstone's got a much weaker case and may not have brought the case at all. See, in order to be misled, you have to be the receiver of a misleading statement, or the other person has to omit something that is relevant, that they know or should have known. In this case, it was the second one. The court determined that Mr. Cook knew or should have known there was a water issue at his home. And you may be wondering about the inspection that didn't take place. To me, that's a real issue for Mr. Poundstone. The court did not penalize him for it. Essentially, they said that it's not contributory negligence to not do as much due diligence as possible. I'm not going to quibble with the court's logic there. What I am going to quibble with is the notion that anyone should do less due diligence just so that they have a good lawsuit to file later on. You don't want to be in a position that filing a lawsuit is the best alternative. Get someone in there to inspect, make sure they got a moisture meter. This could have been discovered. This didn't have to end up in court. So there you have it, Poundstone versus Cook, a case that didn't have to be, but it was, and it cost Mr. Hook a lot of money in the end. Make sure that when you're working with a lawyer, when you're selling your place, that you're strategic about the things you disclose. Err on the side of disclosing, own the narrative. You really are going to give the buyer very little to come back and accuse you of down the line. Sleep better at night.